You have questions, we have answers. This is Jane Muller.
And this is Ken Muller. Welcome to our show, all about real estate with Ken and Jane. And today, Jane, the focus is going to be on the estate portion of real estate. And we're going to talk about estate planning, and then we're going to tie it in a little bit to real estate. And to help us with that, we have as our guest today, Terry Finkelstein. He's an attorney, and he's going to discuss with us all the importance of estate planning. Terry, welcome to our show.
Thank you very much, Jane and Ken. Thank you for inviting me to the program. I greatly appreciate the opportunity to speak with you and the listeners today.
Okay, that's great.
Terry is an expert.
Yeah.
You've been in business for many years. I've been in business only 15. I know you from the beginning.
Right.
Yes, it's fantastic.
Right. So today's focus is going to be more on the estate planning, but we are part of the show. We're going to talk about how real estate ties into the estate planning. So, Terry, please give the listeners an overview of your firm and your contact information.
Thank you, Ken. I'm a solo practitioner attorney. I provide a wide set of services, including estate work when people pass away, wills, living wills, durable powers of attorney, and I also do expungements to erase people's prior violations or even arrests, divorces, child custody arrangements, municipal court cases, which are, of course, traffic tickets. I am the only attorney in my practice, so you know who you will be dealing with. You will not be given to a new and experienced paralegal or attorney.
Great. So one-stop shopping, which is the advantage of a solo practitioner, and you're local to the Central Jersey area. You're based in East Brunswick, but I'm sure you cover everywhere in Middlesex County and adjoining counties, right?
I cover all of New Jersey, Ken. My office is at 6 Cornwall Court in East Brunswick. My phone number is 732-254-1300. That's 254-1300, and I cover the entire state of New Jersey. I'm also licensed in New York, but I'm basically not doing much in the way of New York practice right now other than estate work.
Okay. Very good. So some of the things you mentioned with estate planning, we're going to cover in next week's show. We're going to have you come back next week. We're going to talk about like the living will, the durable power of attorney, and all that. But let's to start with, let's talk about why is it important for everyone, every person to have an estate plan. People would say, well, you know what, if I die, I don't need it. So can you please explain the importance of having something written expressing your requests and, your beneficiaries?
No problem, Ken. You need an estate plan to make sure that your assets, all of your bank accounts, stocks, bonds, real estate, etc., is going to go where you want it to. Even if you only have a few of these items or not very much, you still need to consider an estate plan. If not, your estate may not go where you want it to. So, for example, if you die without a will, that's being intestate. Used to be when a father passed away, the wife would not receive 100% of the assets of the estate. That now has been changed in New Jersey just a couple years ago. So now, God willing, everything does go to the spouse or to the wife or husband if the other spouse passes away. Previously, the kids would receive a third or half of the estate. Mm-hmm. So it's very, very, very screwy because you would not want the kids to do that.
Okay, so if for a husband and wife, and that there is some marital protection afforded, that even if they, God forbid, don't have a will or a living trust, that if one of the spouses dies, the other spouse, the way the New Jersey statutes are geared to protect the surviving spouse, so she will get 100% of the inheritance from the husband or the wife.
That is correct, Ken. The New Jersey legislature finally had some common sense and passed what is a very, very reasonable law. But still, if you have an intestate estate, you will still have to purchase a bond if it's a significant estate, and that's money that you don't need to do, assuming you have a will that says no bond is needed. So it just causes needless expense to the estate.
Right. And your office, again, there's no such thing as a simple, well, people use the term simple will, but if a husband and wife want to come to your office and they need a will, and we're going to talk about the will versus a living trust. I know that can get complicated, so we're just going to talk about the differences and why one would choose a will versus a living trust. But if a husband and wife, you would recommend that it's just makes good practical sense for a couple, even if they want everything to go to each other, to still have a will, because then just expressing that, it avoids, like you said, the complications of having a bond and other potential delays in the estate passing.
That's correct. Sometimes you have someone who's older that you want to leave something to. Sometimes you have a curiosity or a baseball card or a comic book that you want to give to a particular person. That will not go unless you set out specifically who is going to receive it.
Right. So the husband and wife, they can bequest certain specific assets to go to the non-spouse, right? It's just the marital property that cannot be bequested to anybody other than the surviving spouse?
Well, the marital property normally is in the name of husband and wife, and that passes directly. And usually that is not part of the estate. That goes directly, which is a good thing.
Right. How about if it's an investment property?
Then it will, depends whose name the property is in, but if it's in both names, then obviously as husband and wife, it will go to the other, even though it's an investment property. If it's only in one name, then it goes into the estate, and it will be divvied up as per the terms of the will. There's no federal estate tax. It's interesting. I looked it up yesterday just to make sure I had the most common amount, and the amount is now $13.61 million for the federal estate. They key it now to inflation.
I remember back in the day, it was like 3 million, maybe 10 years ago, and then it kept going. Yeah, they adjusted it, that's still a pretty healthy amount that you don't have to worry about.
Exactly. And they did away in New Jersey with what's referred to as the estate tax. So you just have an inheritance tax.
The estate tax used to be $675,000, which was a relatively narrow or small monetary amount. If you have a house, a real estate property, then it can easily trigger it.
Particularly with the value of houses the way they are going up now.
Sure.
My God. Yes.
Well, Jane can speak to that.
I only know about the house value, nothing else. I'm glad you two have a very good conversation because that's beyond my knowledge now.
So a will, the will can be a handwritten document. It can be obviously typed up. You need the witnesses and notary. And so that's relatively, but there's a whole topic with living trust, and people are always asking the question, should I have a will or should I have a living trust? And I know we don't have much time and we want to cover other things, but can you give some, I also should say that our interview is just intended as some general information. It's not intended as specific legal advice. If you need specific legal advice for your particular situation, please contact Terry and arrange an appointment with him. But just as some general guidelines for doing a will or versus the need to do a living trust.
Thank you. The amount in the estate is going to be an important factor in determining whether you need a will or a living trust. The age of the person, the older you get, the more perhaps you need the living trust. And most importantly, the health of the person. If the person's not doing well or only has a year or 2 years, 3 years to live, obviously you need to protect your assets. So basically you would talk to the person, see how much is involved. If someone only has $50,000, $100,000, it doesn't pay to go forward with a living trust. What a living trust is, you put everything, the real estate, bank accounts, into the name of the trust, which is usually trust of ABC. And then you can do whatever you want. And then if it's a living trust, you have The trust provide that the property goes to wherever you want to, and you don't have to probate a will or do anything like that. The property passes automatically on death of the person.
Mm-hmm. Right, and then I guess with the trust, you can also designate a certain like payments, stipends every year to the different beneficiaries in the trust, or you can spread out the wealth, the distribution of the wealth.
That is correct. You can say whatever you want to, and you can provide for children, grandchildren, great-grandchildren, whatever you need to, so that the property goes where you want it to, and the person gets it, and there's no tax, so that's a good thing.
Right. Oh, so it would pass, again, under the general guidelines, the money would pass, it would avoid any estate or inheritance tax if you set up this trust operation, and then a trustee would be in charge would have the fiduciary obligation to execute the intentions of the deceased per the trust agreement.
That is correct.
I see. Okay, that's a big thing. So wills is, but anyway, let's go back then to the wills, which is the more common tool. So with the will, Terry, if you want to just give us an overview of what a will contains in it, and what provision should a will address?
Will does not have to be very long. My wills are generally 3 pages. I don't charge per page, which many attorneys do.
Yeah.
And they make it much, much longer, much more complicated. We keep it nice and simple,
Sure.
and you can understand what it says. First, we pay bills. Unfortunately, when you pass away, the bills do not disappear unless there's no money to pay it.
Sure.
People ask me all the time, so-and-so passed away, and the wife or child says, now I don't have to pay the bill. And so long as there's money, you have to pay the bill.
Right.
The will also has what's referred to as the executor or executrix, the person who is going to get all the money together and real estate, and once she has the money, then she pays it out to the beneficiaries, the people who are going to receive it.
Okay, perfect. We're going to just take a short break, and we'll be right back after these messages. Okay, welcome back to our show. We're going to continue our discussion with Terry Finkelstein, an attorney, talking about estate planning, and we're on the subject of wills. So you were discussing the role of the executor in the will.
That is correct, Ken. The executor basically puts all the money together and then pays it out to the beneficiaries of the estate. In addition to the executor, you then provide who is going to get the estate. Normally, if it's a husband and wife, the husband leaves everything to the wife, or the wife leaves everything to the husband. And we also provide that, God forbid, one predeceases the other, that the estate will go to normally the children equally. So if there are 2 children and husband passes away, wife passes away, then everything goes to the kids equally.
Right. And that brings up something I wanted to ask you about. It gets into the legal terminology, because then somebody like with your knowledge would obviously delve even further, that if the estate were to pass to the 2 children, and let's say each of the children, have children of their own, grandchildren, so then you'll have to address in the estate plan. Let's say, God forbid, one of the children is predeceased, both the marital couple. Then are provisions made that the inheritance from that child goes to the grandchildren, or it goes entirely to the other surviving child? That gets into the per issue, per stirpes, if you want to expand on that.
Yes, Ken. Normally we provide that if both parents are deceased, then the children get the money per stirpes, which means they get exactly what they were going to get, what their father and mother what they were going to get. So if there's 2 children and one of the children has passed away and he has 5 children, the class is not 6. It's not the 1 child and the 5 kids. the grandchildren,
Right.
it would be just 2. And one child would get half, and the other 5 children would share the child's half.
They would
So
get
they would get one
one-tenth,
tenth
yeah.
each.
Right, because they're half times 1/5. Right,
Exactly.
so 1/10 each. Yeah.
Yeah. How about if the person, right, want to make it a difference? Say, for example, right, if the parents, the grandparents in the case, right, the parents, they have 3 kids. Okay, 3, and then the 3 kids have a different number of children. Right? If the parents, one has no children, the other 2 have more children. So how about the grandparents that in the will, can they say the other 2 get more or no?
They can.
They can.
Yes, Jane. Then you would say per capita,
Yeah.
which provides that the class is enlarged.
Yeah.
So there's the number of people who are in the class are the number of grandchildren plus the children.
Yeah.
So you would have, in the case of I just gave, where there's one child that is still alive, the other child is predeceased, and he has 5 children. You have 5 plus 1, so your class is now 6.
6.
So
yeah.
each one would get 1/6 of the estate.
Yep.
And sometimes that's what the the person who creates the will, the referred to as the testator, that's what he wants to do.
Yeah.
And basically the job of the attorney is to do what the attorney, what the client
Yeah.
wants
To do, right.
I mean,
and you
what-
can express, you can do whatever you want. Like, I mean, it may not be whether it's ethically or morally correct. Sometimes, and Terry can correct me if I'm wrong, but you can exclude a child, you can exclude grandchildren if you have no, I mean, that's people, for whatever reasons, they may want to purposefully exclude somebody from the will. And I think Terry would say in the will, you'd have to put in I'm not including Marianne, my daughter specifically is excluded, or, verbiage to that effect to make sure there was no mistake about it.
It's interesting. Sometimes it's because that child has a tremendous amount of assets and doesn't need the money. Other times they
had a
child
fight.
fight or does not want to leave anything to that child. And you can do it. We generally try to talk the person out of it
Yeah.
because they do the will and then they reconcile and they're
Yeah.
They
back
have to.
in good graces with the parent, and the will provides that the child does not get anything. So
Yeah, I think a lot of time it's not the thing, it's the feeling. And for the listening, for our audience listeners out there, please, if you don't have a will, please call either, call attorney, call Terry, call anyone you feel comfortable, and let's set up the will. That's very important. You want to make sure, obviously we all want to be happy and the longevity, but at the end of the day, to be prepared, nothing wrong to be prepared. So if you want you make your family less troubled, right? And you put what you want with your lawyer or with professionals you chose to be, but make sure you need to have something in place. Yes.
that's correct, Jane. We used to give 10-year guarantees with our wills, but that didn't work out too well, so we stopped doing that.
Right. So, and then besides that, so the will is going to have you have to pay all the debts and the funeral expenses. You're going to have the appointment of an executor. You're probably going to have you're going to have backup executors or executrix in the event that the primary executor is unable to serve due to death or disability or what have you. And then what else would you put in the will? Some specific bequests, or you could put all my real property and personal goes to my beloved wife.
Excuse me, I have a simple clause that just says real property and everything that I have, I leave to my wife. God forbid my wife predeceases me.
Then-
Everything goes to the kids.
Right.
Per stirpes, as we said.
Right,
And then
but
I
it's-
explain.
And it's so important, I think, to have an attorney like yourself do the will, because if people try to do it themselves, their intent may not be legally correct. So it's just for the it's a small investment to ensure that the future well-being, of your wishes is carried out. I think so. I think it's just like Jane said, it's just this very smart idea to have an attorney like Terry do the will for you.
Yeah. Another things I heard with the real estate, right? Sometimes the if there's a second marriage, right, particularly, and the person who had the house, obviously, they don't want to leave the house to the spouse because that's once again that's later in the marriage they already had a house. They want to give their children. They can put in a will to grant the person to live there, right? That's happened a lot.
That's correct.
Yeah, for real estate purpose. Yeah.
Mm-hmm. I mean, give them like a life estate
where
they could live there,
yes.
and then upon that person's death, then it would pass to however they...
whatever the will we're going to
Excuse me, that's very complicated, though, because there's a question of who pays the maintenance on the house, and more importantly, who makes repairs. God forbid there's a hurricane, you need a new roof, you need a new water heater, you need a new furnace.
Right. That opens up a whole can of worms. And then I guess if that's going to be done, then somebody like yourself would say, well, we have to address for the...
That's why I have a professional have that done right is super important. Nothing worse than you thought you did a will and later on it doesn't, or someone can challenge it, or the will wasn't clear enough. I mean, for the person who wrote it is clear enough, but for the other people read it, this could be confusing.
And also from the substance and likewise from the procedural aspect, because there's very specific language, as I recall, in New Jersey that has to be in the will for the notary and for the witnesses to make the will self-probating versus having to bring the witnesses back to the court. And if Terry, if you could kind of expand on that point about how that all has to be done very, very carefully.
Yes, in New Jersey, you need at least 2 witnesses on the will, and basically it's self-executing. Yeah. So you have to say that the witnesses and the notary, who, when I do the will, I'm the notary, have signed it voluntarily and not under the influence of alcohol, drugs, or anything else like that.
Correct. And I even think I think it varies from county to county, but I think even some counties are very particular that when the witnesses sign the will, they have to say that I'm witness. They can't just say that the signatures on they have to mention the name of the testator by specifically that, there's some counties are very picky with the language. They can vary, I think, from county to county. So you really need a professional guidance to make sure that otherwise if your will may not be self-probating, and then it's more complicated to go with. And let's talk about with wills the need for probating. That's the whole thing. People say, oh, do a trust to avoid the probating the will, but probating isn't really that bad. If you could explain what probating a will means.
Probating in New Jersey is very, very easy. People are afraid of probate. In New York City, it's difficult. I had an original will in New York where I took out the staples to make a copy years ago, and I needed to provide an affidavit explaining why there were staple holes in the will, in the original will. Unbelievable. Wow. But New Jersey is not so finicky, and it's very, very easy. You basically fill out a form usually with the information. You supply the original will. You supply the original death certificate. You get the original death certificate back, and you provide the information and a fee of under $200 usually, and poof, within 2, 3, 4 weeks, you get what are referred to as letters testamentary, which allow you to do things with the assets, with the property, and with bank accounts. You need to get forms L8 and L9 and file them. And there's really, it goes very, very quickly and very, very easily.
Right.
Yeah. I have a question. Say, for example, right, if they have a probating the will in the interim, can the house to be on the market? Because you're not going to close, soon. So typically you put on the market, by the time marketed, go through the process. It's about 60 to 90 days
I guess the
cycle.
Jane's question becomes, does the executor, without having the will probated, can you put the house on the market based on the executor's signature on the unprobated will? I think that's what your question is, right?
Yes,
because
thank you.
Yeah, that's what it comes out. Yeah, because you have to, otherwise, normally I think to probate the will, you have to wait, I think 10 days before you can bring the will to the county.
Yeah, I know the 10 days rule. Yeah.
So your question is, if God forbid that they call you 3 days.
10 days later.
I'm saying the
so.
son or daughter of the deceased calls you 3 days after right after the funeral and says, we want to put the house on the market.
Yeah.
I'm the executor. Can they go ahead and sign the listing agreement
Yeah.
prior to that will actually being? That's a good question. I don't know.
Yeah.
If that's
The answer is yes.
okay.
So many, many times they want to get rid of the house, sell it as quickly as possible. And I tell them, go ahead, sign as the executor. And then once you get the executor papers, then basically you have the actual authority. But you have implied authority right away.
Okay, implied authority.
And you can go ahead and do it so that you have no problem.
Yeah, I had that case years ago. I can't remember at the end. The lawyer have, like you yourself, have to give a decision because both children out of state. They came here for the funeral. After that, they have to leave. And they let me in charge of empty the house, get it ready, get it on the market. But at that time, I wasn't sure. So I said, you have to consult your lawyer. At the end, I believe a lawyer wrote me something and said, yes, you can put on the market.
Okay.
So, yeah,
Good.
but I didn't know why. So
So we're going to have Terry come back next week. We have about 1 minute left. So real quick, Terry, what life events would necessitate somebody updating their will and recontacting you?
Thank you. Life-changing events occur when someone passes away, a spouse passed away, and the spouse may remarry. One of the children passes away, God willing, or you have more children. So you leave
So those
everything to your 2 children,
Yeah.
and all of a sudden you have 3, 4, 5 children.
Or you have grandchildren coming from, they might want to provide for them. Right. Great. Thank you so much. We are just about out of time, but one last time, please give your phone number so our listeners can get in touch with you.
Thank you, Ken. It's Terry Finkelstein again. It's 732-254-1300, 732-254-1300. Thank you.
Thank you so much, Terry. We're out of time. We'll see everyone next week. Have a good one.
thank you.